Good afternoon, everyone, or to those that it relates to. Good morning. Thank you for joining us today. We have a very special presentation and panel. We have titans of the receivership industry on our panel today. We're going to have a lot of fun. This is episode 2, How to Administer Receivership of the Financial Poise State Court Receivership series. You can read more about financial poise on slide 40 of this presentation. Today, our panelists are Rebecca DeMar from Swanson Sweet and Cali Resolution Partners. We have Sandra Jacobson of Plant Moran and Martin Wasserman Carlson Dash. My name is Matthew Brash. I'll be your moderator from New Point Advisors Corporation. You can see our names on slide 5 of the presentation, or you can read our bios through slides 32 and 35. Neither Financial Poise nor we intend this to be an infomercial. So you don't have to listen to me read our bios, but if you want more information about us, please look at our bios or check out our websites. About the slides, this is more of an open forum discussion item. The slides are not necessarily critical to this webinar, to this discussion. So if you are listening but not watching, that is okay. We just want you to be able to learn something and take away a couple of things. And as previously stated, if there's questions, feel free to submit those. I'd like to thank our co-producers, the National Law Review and Daily DAC. I'd also like to thank our sponsor, Max Asset. In addition to that, you can read more about our co-producers and co-sponsors on slides 36 through 40. The last thing I want to bring to your attention on slide 4, it contains a disclaimer. You are not our clients. We are not your lawyers. We do what we do here and say here today is for your general education and not for you to act on without appropriate advice. So without further ado, we will get this going. How to Administer a Receivership, Series 2. And just so you know, we have a couple upcoming episodes, Asset Sales and Receivership on May 21st, and How to Conclude a Receivership on May 28th. So without further ado, let's get going. Rebecca, how do you determine and clearly define the receiver's scope and authority at the onset of a receivership? Explain the importance of reviewing the receiver's order prior to the appointment. Oh, you're on mute, Rebecca. Sorry.
Sorry, I wanted to stay quiet while you were talking.
No problem.
I said thank you. First, it's important to think about obviously what state you're in, because no matter what the order says, the state law and the type of receivership that it's going to be will drive what the order can say. I'll get to the order in a second, because that's probably the most important overarching thing as the matter goes on. But, depending on which state you're in, there can be all different kinds of receiverships. There can be selfish receiverships where you're collecting just for one person. There can be foreclosure type receiverships like you typically see in Illinois, where, you're really going after keeping things stable on a particular piece of property. And there can be one that look and act more like a Chapter 11 bankruptcy, which we do a lot of in Wisconsin, where I split my time between Wisconsin and Chicago. So a lot of that in Wisconsin, and increasingly in other states. So the kind of receivership it is going to drive the scope and what you're going to do. Are you going to have powers to sell assets? For instance, are you going to have powers to operate the business? How much authority do you take over? That being said, everything's in and should be in the order. My current form of my order is, I think, 22 pages. It gets tweaked a little bit depending on the state and the lawyers involved, but I do try to make it comprehensive so that I can look back to it and point to it depending on the situation over and over and over again throughout the case. It's going to say, like I said, the scope, like operating the business, selling the assets, those are really high level scope issues. It's also going to say what you don't have to do. So the form of my order has me not dealing with the 401k, has me not filing tax returns, for instance. I did review an order recently for somebody who was appointed, who didn't do any receivership work. And it was 2 pages long. And with that order and no further orders from the court, she operated and sold a winery and dispersed. and that's crazy. I mean, sometimes you do things outside of court, right? That's what Illinois assignment for the betterment of creditors, for example. But if you've got a court, I don't see any reason not to get orders to, protect you and step forward the roadmap.
Completely agree. Marty, a lot of court jurisdictions want a receiver present at the hearing for the presentment of the receiver. What is your experience in having the receivers present or not present? What did you find to be the advantages? And being a receiver myself, I've always found it being advantageous. What have you find from a legal perspective or for representing lenders or just general receivers in general?
Thanks, Matt. There's a variety of reasons that it's important the receiver is there on the appointment day or when the motion is presented. The first is just, the court at the end of the day is the one hiring you. And the court might have questions about your qualifications and if you are the right receiver for the job. So you want to obviously be appointed as the receiver. So you need to be there to answer about your prior experience. Do you have this type of experience related to the company that you might be operating or type of collateral that you might be overseeing? The court also might just have questions about what collateral or what type of business this is and what kind of due diligence you've done beforehand. No, some of those obviously, receiver can answer on day one, and some of it you need to get into. But, the court might want some guidance, and that goes into the scope of power and authority that Rebecca was just talking about. This court might have questions about the order. And what you need or what you don't need, and making sure that it gets it right. Beyond that, there's also just going to be, scheduling questions that the court has for you about how quickly it needs to get back. And I know we'll get more into the receivership order, receivership powers as we go. But, being there on day one, so you can kind of set the scope for the court and how broad that you need that order and how much latitude that you need and how quickly you have to be back in front of the court or not back in front of the court is something that you want to guide and control as the receiver.
Yeah, I completely agree. And one of the things about being a receiver, and Rebecca stated, is that the importance of having everything you can possibly ask for, a 22-page order that gives you everything under the sun, the stars, and the moon, that allows you to get off on the receivership on the right track and not have to come back multiple times and ask for permission to do something. Chandra, what happens in a situation where either a judge won't give you those powers up front, but as you get into a case, there is that need to amend the order, or as you get into the case, you discover something. How do you go about amending the orders or asking permission to do something, or if something urgent comes up, on an emergency basis? What are some of the steps that you take to get those potential scopes or items into an order, amending that order?
Sure. Thanks, Matt. So, we've talked a lot about the order already. The order, for lack of a better term, is essentially, your Bible, right? So I routinely review the orders, maybe every 2 weeks to just be reminded of what my requirements are to the court as the court's receiver. Obviously, there's going to be some key information in there from a compliance standpoint that you're going to want to make sure you're familiar with. What reporting is required? What is the reporting cadence? It'll have information about, how professionals need to file fee petitions in connection with, getting paid and all that kind of good stuff. So routinely review those. And to the extent that you do need to amend the order, in the vast majority of the cases I handle, I retain counsel to represent me as the receiver, and I'll communicate with counsel, and counsel will communicate with, and typically it's the secured creditors attorney that's representing the lender in the case regarding an upcoming motion that might need to get filed if we need to amend an order or seek additional authority that perhaps I wasn't granted when I was appointed based on the original order.
I completely agree with you. Rebecca, when you're appointed, and same goes for you, Chandra, what are the essential first steps a receiver should take immediately upon appointment? And also, I want you guys to discuss about giving notice to all parties, especially the entity under the receivership or anybody else. Rebecca, and then maybe Chandra, you can go next. Those first steps, those key first steps.
Sure. Before I talk about that, I just wanted to follow up on something Sandra said. Twice now, I have been appointed in shareholder disputes as receiver and actually gone back to the court, not only to get an amended motion or amended with a motion, not only to get an amended order, but to actually flip it from like a shareholder dispute receivership to a more comprehensive, looks like a Chapter 11 receivership. So, I mean, amending that order doesn't happen in every case, but I bet it happens in 15-20% of them. Okay, first steps. Depending on what you're walking into and how much background you've had, that can feel like an absolute tidal wave. So even responding to the question I thought was kind of hard, because I was like, well, first steps in this one versus that one. You're going to want to figure out what you have, secure and inspect the assets. That can take anywhere from a day to 2 months, depending on what you're dealing with. You're going to want to check on insurance of all the different kinds. Going to want to find out if you actually have employees, like W-2 employees, and what you're going to make some quick decisions about what you're going to do with them. And then I probably start looking at notice, and I'm using that broadly because, no matter how you got there are likely going to be more than one, quote, secured creditor, end quote, that has an interest in what you're doing. So now you're looking at trying to figure out who has what interest in what assets, operating or not operating, and then what the law and or the order require you to do for notice. In the ones that look like Chapter 11s, you notice everybody. Notice is your friend. You want to do it as broad as possible and bring all those claims and objections forward before you get too far down the path, spend too much money, sell some assets, etc.
Excellent. Sean, how about you? First steps.
Yeah, I don't completely agree. I don't have a ton to add. I mean, I would just maybe add UCC searches, right? Just so you understand for yourself who's on first and who's on third and whatnot. If it's an operating receivership and there's a management team and employees, depending upon what the objective of the receivership is, and I guess to back up, number one, right, get control of the cash. But moving forward into some of the conversations that need to happen, right? Because you're coming into a distressed environment. Typically, these companies have been underperforming. The management team is under pressure. The employees are worried about, if they're going to be employed tomorrow and whatnot. So just communicating with the management team, getting an understanding of exactly what you have. But then also, it's a decision-making role. And I think that is a very important message to deliver to the management team on, day one, because if you're out in left field working on a work stream and you've got a management team member ordering a bunch of inventory that you're going to have to pay for that you may not need, that's going to be a problem. So just making sure you level set with the folks that you have there that are employees of the company to the extent that it's an operating receivership.
Completely agree. And just sticking with you, Sandra, what are common pitfalls receivers face when transitioning control from the defendant or previous management?
Yeah, I know we heard about insurance. I think that, as obvious as it sounds, can be overlooked at times because you are drinking from a fire hose in the beginning of these cases and you're trying to, check all the boxes almost at the same time. That would be one. I think getting control of the cash, opening up a separate bank account, a receiver account, to just add another layer of protection, making sure you're communicating with the lender. If you're going to be doing that, you'll be utilizing the proceeds of their collateral. So making sure you're aligned as best as you can be with the secured creditor on a weekly, cash flow forecast if you're operating. Those are some items that come to mind. And then again, just securing the assets, making sure you've got system access, you've appropriately implemented security strategies if you think you need to. I mean, we've retained ex-policemen to be on site if we think that's necessary for whatever the reason might be, right? If you're going to have a reduction in force, if you're concerned about things disappearing, it does tend to create a pretty chaotic environment, at least in the beginning. So those are some things that come to mind.
Rebecca, anything you have to add?
Yeah, I mean, all of that. At a fundamental level, I think the decision needs to be made. Do you keep, and now we're talking about an operating business, obviously, but do you keep the management that's in place, or do you bring in different management? Is it some of both? That's an early decision point. My bias is to keep the management in place unless I have a reason not to, because that's going to keep things as going as smoothly as possible on the operation side. But at the same time, getting them to understand that they're now answering to you, ultimately, that it's your duty, your fiduciary duty. What money goes out the door, what they're telling other employees, the messaging to vendors, customers, etc. Getting control of that. You need to be able to get control of that to keep the management that's in place. And sometimes you can't.
Great. Marty, from like a legal perspective, what do you see when you're dealing with, because you're either representing the lender a lot of times and a receiver doesn't have counsel right away and they're kind of coming to you as the petitioning party, or also in your experience in representing receivers, what do you see as far as like the pitfalls in transitioning control, and what are some of the things you see from a legal perspective?
Yeah, it really goes back to the first topic we talked about, which is the order. Making sure the receiver has proper authority that third parties can rely on. When you're going into the bank on day one saying, hey, I'm the receiver, I need access to all these accounts. If you don't have a clear statement in that order that you have that, they're never going to let you walk out with that. And it's dealing with creditors, dealing with landlords, dealing with third parties, that you have a clear statement that you're allowed to do this and they're allowed to rely on you doing this and take it over. Because you'll run into it's one thing to deal with the parties where they're in court and they can see the orders that are entered and they were in front of the judge. But when you're dealing with third parties, they are actually, they're completely new to this. And without a clear statement, they're going to kind of say to you, not my problem. So you really need to have clear statements in the order that you, especially with bank accounts, that you have authority to take over all the accounts, switch signatures, transfer money from the accounts, bar other people from it. And you want that in relation to insurance, accounts pop, because that's usually where you have it, where a bank isn't going to let you transition. But really in all aspects of the receivership, you want to be able to have that authority that third parties can rely on you being the receiver and can run with that and let you run with it so you can actually take control of the assets.
So Marty, we're appointed as receiver. We get on site. We've got either an operating business or a piece of real estate, and you've got these pre-receivership obligations. Talk about discuss payment of pre-receivership expenses, critical vendors, employees, taxes, payroll. When does it need to be paid? When shouldn't it be paid? How do you go about really evaluating what needs to be paid and what doesn't need to be paid?
So it all goes back to the order appointing you and the scope of your receivership. Because truthfully, what type of receivership you're managing. Rebecca talked about, some of these that are almost like Chapter 11 liquidations. And then, pre-petition, what we'll call pre-petition or pre-receivership creditors really just need to get in line. They need to file their proofs of claim or whatever the state, court sets up to line up. And then you could pay basically out if there's money after the secured creditor is paid. But there's other times where you have an operating business that truthfully, you want that receivership order to give you some wiggle room and scope to decide what needs to be paid. Because guess what? If these employees aren't paid for their last paycheck, they're not going to show up tomorrow and then you're done. Taxes, especially federal taxes, are a whole different scheme. And sometimes you have statutory requirements that you do pay them and you pay them with a certain priority, usually right after collateral is paid, and receivers always have to be aware of what the federal tax, not only employment taxes, but all federal taxes are, what is outstanding, when we were talking a minute ago about, first steps and UCCs and so forth, but also really getting an understanding of what taxes are out there and what needs to actually be paid. And beyond that, it really is the scope of the receivership and what the court allows you to do, and how beneficial it will be to the receivership going forward for you to pay it. You're going to have some vendors that, if they're the vendor giving you, your inventory that you absolutely need to run the company, they have some leverage over you. But there's going to be a lot of vendors that's not true. And then it's just really the receiver's business decision, subject to the scope of the receivership and subject to the court's orders to you.
Okay. Rebecca or Senator, anything to add to that?
Yeah, I mean, I would just echo the form of my order does give me the ability, the legal ability to pay those kinds of, pre-receivership obligations. It's a constant judgment call on what you're going to pay and what you're not going to pay. And it depends on it's very specific to each individual case. And it's really all about how are we going to maximize the value of these assets. And if it's necessary to maximize the value, then it probably gets paid. That being said, I almost always figure out a way to make sure payroll's paid. I'm trying to think of an instance where I didn't pay payroll. I think I've always paid payroll. But a lot of it, and I think we'll get to this in a little bit, obviously ties back to the budget and what the plan of the receivership is. Where's the money coming from and how are you going to actually, pay these things?
Okay. Rebecca, sticking with you, what strategies are effective when dealing with defendants actively obstructing asset recovery or operational management?
I mean, I would love it if somebody has an actual, checklist of strategies to deal with these folks, because I'll take it, I'll study it. I will say that to the extent I have what I would call firm strategies, one thing is to come at people in different layers. Have the lawyers come at them and then the receiver come at them. And then if there's other consultants on the ground, I work a lot with one consultant in particular who goes in on the ground, and we don't even think about it anymore. We automatically play basically good cop, bad cop. He's the good cop. And so we're adding yet another layer of, well, I understand I would, but Rebecca. And then when it comes to me, it's like, I understand I would, but the lawyer. Right. And that combined with a lot of communication, because honestly, when they're being obstructive, they often just don't understand. So that's another way that we come at it. I mean, the way I explain it is different than the way the person on the ground explains it, which is different than the lawyer explains it. So the more angles you can get in there, that's often more effective than not, I think. But yeah, I don't know.
Each situation is so unique and so different, and the personalities can be so different, ranging from scared and you hear the phrase like, this is my first time ever involved in this, and they just don't know what to do or who to trust or how things should be going. So I agree about the good cop bad cop, or you trying to have to be you're an officer of the court, so you're just doing your job. Chandra, how can you're in there as the receiver, you've got a company and you've got all these eyeballs and ears looking at you, having taken over basically the entity, and now you're in charge. How can a receiver manage resistance or interference from employees or management teams of any place in receivership? Like, how do you go about, earning their trust or getting in there to make them say, listen, like, we're here for a purpose. No one's going anywhere. Like, what are some of the things that you do going on site, or what are some of the mechanics, things that you put in place?
Sure. I think it's important to gain confidence early, and we do that through a lot of communication and by demonstrating that we've done this before. We're an officer of the court. We know what we're doing. Here's the plan. Here's the objective of the receivership, making sure there's alignment with the stakeholders there. You may not be aligned with the equity there, right? Because this could result in them, essentially losing the business if there's a transaction. But trying your best to gain confidence. And I've had pretty good luck, knock on wood. I mean, I've certainly run into my fair share of, obstructions, and I've been locked out of facilities. I've had to call the local authorities, and scrambling to get a copy of the order so I can show it to the sheriff, who doesn't want to be there, at all, and has no idea what I'm talking about when I'm trying to show him a receiver order and explain to him that I'm the court-appointed receiver and I've been locked out. But that would be an exception, not the rule. And to the extent, like has previously been mentioned, I have to, if I can't resolve it amicably, then get counsel involved, try that. If that doesn't work, then we're going into court, and whether it's a motion to compel or whatnot, we're getting in front of the judge. And you typically don't have to take it that far because judges tend to not appreciate that. So normally you can resolve it, but people can get pretty emotional, and you do have a few doors slammed in your face from time to time.
Yeah, there's nothing like an police officer or a sheriff showing up to the door and you've got that order. And God bless.
No idea.
Yeah, Rebecca's got a 22-page one, so they're just like, "What? Okay, show me what this has to be."
That's
yeah,
always either 100. It's always either 100 degrees or 20 degrees.
it's like dead of winter, or it's like the hottest day of the year.
Yes.
Thanks. So Marty, when and how should a receiver escalate issues of non-cooperation to the appointing court in violation of the court order? Under what circumstances do you see and do you recommend when receivers should consider seeking contempt orders or sanctions against resistant parties? I know for myself, I can get very aggressive and saying like, hey, if I don't get that cooperation in that 5-day window, like, let's go, like, no patience, let's get going. But then I can come in front of a couple of judges who are like, slow your roll, give them another 5 or 10 days. So like, there's that balance, right? Like, how do you deal with that? What do you recommend?
I remember a couple of those instances, Matt. So it's a little bit of a sliding scale. And I would say the first thing, to echo what Rebecca and Taylor were saying is, honey is the best option here. See if you can get cooperation. Any court is going to want to hear your efforts to get them to cooperate. But then again, it is a little bit of a sliding scale that if you're dealing with the core of the receivership, the bank accounts, access to the actual real estate, and they won't let you in there, they're preventing you from getting control of the accounts, then you got to act pretty quickly. Obviously, you want a little trail of, we emailed them, we called them, we showed up at the property several times, and they refused. In those instances, that's the core of what you're doing, is conserving that property. You need to be in court relatively quickly. But then there's also items that, strike more as discovery disputes than the core of the receivership. When you're looking for historical documents, you're asking, interrogatory like questions to them, that, a court really is going to want to see that you've gone through what is normally required in discovery, that, if you have counsel, that your counsel's reached out to them, you've tried to have calls with them, you followed up with letters and so forth before you're running into court on, day 5, saying they haven't given me, the last 12 years of tax returns. So it really depends on what you need. But, those core parts of the receivership, you do sometimes need to be very aggressive. Otherwise, your receivership can go poof pretty quickly.
Yeah, and communication is extremely important, like you said, whether it's with the court or the parties, and you're keeping notes of what you're doing, what you're not trying to do. Rebecca, can you discuss some of your best practices and steps in managing communication with all the stakeholders and all the parties? I mean, you're the receiver, you're the focal point. We're the ones that, we're the arrows are sometimes pointed at us, and sometimes we try and over communicate, but sometimes people accuse us of under communicating, but there's reasons behind it. How do you go about managing? What are some best practices that you see?
Yeah, I think communication is probably in all its different forms is probably what keeps you out of court. I mean, on the when do we go to court point, I mean, these are by definition state courts, right? These are not bankruptcy courts. So a lot of times, filing a motion might get their attention in a different way, whoever they might be, but actually getting, whatever it is, having the amount of time it takes to get in front of that court and get heard and get a decision. I mean, that's a long shot, I would say, more often than not. Something's going to have to give in the meantime. I don't think, I was trying to think if you could over communicate. Obviously, you're communicating strategically, but just like, in dealing with any outside of receivership, dealing with this kind of issues with this many different people, they're going to want to hear from you, and hearing from you, just knowing what's going on solves a lot of the problems. I do this all different ways, of course, again, depends on the instance. I mean, oftentimes we'll start at the beginning of the case. We'll start with twice a week, sort of all hands calls, Teams meetings. That doesn't stick for the entire case, of course, but at least until, you've sold the business assets. Then I'll go to some regular emails. My orders do not typically require me to file updates with the court. I mean, sometimes they do. I have one in Kansas that does right now. But I'm actually leaning toward doing more of that routinely. We've spent a lot of time talking about the beginning of the receivership. I actually think it's the end of the receivership that it's harder to manage these things, or the trailing part of the receivership. After you stop the pigs from dying, the business is sold. You still got a lot of work to do. And that's where I think it gets harder to maintain that kind of regular communication. In fact, I got myself in trouble a couple of years ago at that very tail end part And, the secured creditor stopped asking for budgets. I stopped providing budgets. Sure enough, they were not happy. So I'm changing my process, and I'm leaning toward filing something monthly with the court, even if it's just a couple paragraphs and a, very short P&L.
Sandra, anything to add with that as far as communication that you see? And especially also, that's the first part, but second, talking about managing confidentiality and privacy obligations, particularly when handling sensitive or regulated information.
Yeah, I don't have too much to add. If we're running a sale process or sharing confidential information, we'll have counsel draft an NDA that we'll use. So we're always trying to be careful that way. If we're sharing anything like a payroll register with a party that might be interested in buying, we will redact the payroll as best as possible. I think all they really need to know is, the department that the employee is in and what the employee's wages are if they're trying to build their own financial model or forecast around what the business will look like post-close if they buy the assets. So those are two things that we tend to do. Obviously, it can expand from there, but in most cases, we try to keep it a little more streamlined and while at the same time being careful about obviously what we're sharing.
Yeah, no, I completely agree. And I think that part of, being a receiver is there is that sensitivity. There is times where, I have receiverships right now where I have defendants telling me confidential information that if shared with a plaintiff could potentially blow up any type of settlement discussions or potential sale. And it's like, how do you manage that communication to make sure that, it's all about keeping the receivership moving forward and hopefully have your sights, goals, and objectives on what the end game is, kind of like Rebecca said. So I agree with you completely about it's such a delicate issue, and it's, you're trying to be as open and you're trying to, the point of receivership is to have as much transparency as possible, but sometimes that could backfire if there's too much, but you still got to make sure you do your job. Marty, from a legal perspective about confidentiality and privacy obligations, what's some of your legal advice or guidance on that when, representing obviously a creditor, a debtor, or a receiver?
Two things. Obviously the receiver stepping in the shoes of the company, and it's always important to go back to the contracts that are at issue and see what confidentiality provisions. You don't step it. You step into the shoes, and you don't have a free hand here. So going back to the obligations and the underlying agreements that this company had, and seeing what their confidentiality provisions are. I will say, in the other area I would touch on is regarding employees. I think if there's ever an area to go back to, the court for guidance on, as you are wrapping up the business, transitioning the business, how are you going to handle the employee information, maybe destroying employee information or transitioning employee information. If there's ever something that you want crystal clear guidance from the court on, that is one of them. And, those things kind of develop as they go on. You don't know what they previously did or didn't do as to their employees. You don't know what you're going to need to do if you end up selling the business or, signing contracts and so forth. And getting really clear guidance from the court is really important, especially with employee privacy issues.
I agree. And both you and Rebecca brought up some pretty good points here. That's kind of the next, question here is, Rebecca talked about budgeting. You talked about, timing, and I guess, Rebecca, and then Sandra, when we're talking about whether to continue operating or liquidating, what goes into that? Like, what is you're in there, and as we know, it could take a week or two to get your arms around the situation. It could take a month. It just depends on the quality of data, the cooperation level, the clock is ticking, and, my heart is always racing because I'm like, can we make payroll? Can we do that? Like, kind of talk about, Rebecca, what goes through your steps and what your mind is as far as whether to continue operating or whether we need to say, hey, we need to liquidate this thing.
Yeah, I mean, at a fundamental level, the very first question is, can you use cash to operate? And is there enough cash from operations to continue operating? Or do you need, post receivership financing? Mm-hmm. That's all wrapped up into how supportive, is there a secured creditor? Are they an institutional lender? And how supportive are they in keeping the business operating? Now, there's a lot that's going to go into that decision as well, right? I mean, there's some things you're never even going to know about that's going on their end. and whether, especially if you're asking them to advance new money. But on what you're really trying to do, your job, although my bias is to keep it operating and sell it that way. Those are the wins, right? But my job is to maximize the value of the assets for the benefit of the estate. And you're looking, and I think this gets missed a lot. You're maximizing the net value of the assets. So after you get done spending money on yourself and professionals and keeping the business upright and burning more cash, is it worth more operating or not? Sometimes you just have to make a really quick gut decision and, see if the people who need to give consent or at least advice on that are in the same place you are with it. Other times you have time, right? You have time to get a liquidator in there and figure out what you would get for the equipment not operating. Sometimes you get more for it not operating than operating, unfortunately. But I think keeping the goal in mind, looking at trying to look at the differences in those values, how long it's going to take to operate it and sell it. How are there sellers that are, ready to step in and buy? Do you have time to run a process? All that goes into account. I take all of that into account, but you always start with what's the cash burn of it operating, because it is expensive to operate in receivership. It's a lot of my time. It's a lot of my people's time, a lot of professional time. And that needs to be taken into account in addition to whatever the company was already burning before you got there. You save some with cutting off, if you've got a bar date and cutting off some pre-petition, but even that is difficult to quantify right out of the gates because of those, critical vendors and et cetera that we talked about at the beginning.
Rebecca, you brought up securing, post-receivership funding. How do you go about doing that? And obviously you put a budget together and you see that there is this gap and hole in your cash flow or in your budget. What are some steps, or how likely or how often you see it where you need to go and get, that post order financing, or going to the secured lender saying, hey, we need to fill that gap? What do you do? How have you seen that happen? And the likelihood and success of, someone stepping up and providing that additional liquidity?
I mean, usually it would come from, the existing first secured creditor, frankly, because they're the ones that have the most to lose and they're trying to protect their collateral and maximize its value. In the good situations, you have some time to put that budget together, before you're appointed, and get everybody on board with numbers and process. Doesn't always work that way, of course. But, I don't want to say the post-petition financing documents, well, they vary because they're driven by the secured creditors, but my go-to form is, a quarter of the size it would be in a Chapter 11, but it operates much the same way. And, they are asking to, increase their debt by whatever they're advancing. Most of them, there's some money that comes in, at least to pay for the receivers and professionals, because there's not money in the assets for that, or we wouldn't be there.
Sandra, how do you handle negotiations with creditors or other stakeholders regarding, when you're putting your budget together, you've got maybe a first lien holder, then a second lien holder, or you've got a key stakeholder. How do you handle all those negotiations and managing all the various different creditors and folks that are basically saying what about my piece of the pie? How do you go about doing that?
Sure. So on the secured creditor side, I try to do as much of this, and it's like Rebecca said, it's not easy, right? On the front end, perhaps even pre-appointment, to make sure, because I'm not going to step into the role personally. This is just me. Others might be fine doing this, but I have to make sure that if I'm stepping into the role, especially if I'm operating and I have employees, that arguably I'm responsible, right, for making sure they get paid from the date I get appointed into the future. If I don't have a real good feeling, either because I've worked with the lender before, or for some other reason that we're going to have coverage as it relates to making sure that we can cover those expenses, then I either can't, take on the role, or I'm not going to operate the business. Once you're in there, even if you have that support, I also find that everybody might believe that this company is saleable, right? And what they sometimes don't realize, and it's what we experience when we get in there, is the event of the receivership itself is additional disruption to this business. creditors find out, customers find out. Now you've got someone in your supply chain that's in a receivership. Are you going to keep giving POs to this company that's in a receivership that may be out of business in a week, or are you going to move your business? So just doing everything you can to sort of manage expectations, and you may have to shift. You may have to pivot the strategy. You may be in the middle of a sale process and lose a key customer and have to move or pivot into more of a liquidation. So just making sure that the secured creditors have a good understanding and that everything has been negotiated as much as possible on the front end. On the unsecured side, it's again more about just communication. We spend a lot of time on calls with vendors, critical suppliers that we need material from to continue to operate the business. In some cases, they might be owed $1 million pre-call it petition or pre-receivership. Well, are they going to keep supplying you? Maybe on a COD basis, maybe not. And then you've got a disruption to your operation. So helping everybody to understand what the objective is and over communicating in those cases is important and helps with those negotiations.
Yeah, I think that's really well said. Sticking with you, Chandra, can you discuss best practices in selecting and managing third-party professionals? I know you mentioned earlier in this webinar about you always are hiring and retaining counsel. Talk more about also like preparing that team. You're the quarterback and you want to have the best line protecting you. You want to have the best receivers. You want to have the best person to hand the ball off to in certain situations. What is, when you're retaining professionals, when is the right time, or, who are you looking to retain for what situations? How do you go about retaining them? Talk a little bit about your selection process or even retaining professionals altogether.
Sure. I think it's important to, read the room, for lack of a better term. So, depending upon the size of the case, I think you've got to identify your firm selection appropriately. Tend to work with people I've worked with before that I know and I'm confident in their capabilities to represent me and help me move the case forward. Make sure that whoever this is has an understanding of whatever risk might exist as it relates to potential issues with getting paid on the fee side. I mean, I think there's always an element of risk. I think it's manageable, but I think making sure that everybody understands that it's not you personally that is going to be responsible for their fees, and then messaging too, if there is a secured creditor, to make sure there aren't conflicts, to make sure the secured creditor understands who you're considering as it relates to representation. Just again, I like to do things on a transparent basis to ensure alignment across all stakeholders, especially if one of them is somebody that's funding the receivership, right? And I'm using the proceeds of their collateral to fund the expenses. So I think that is how I would approach it on sort of the legal side. Not too different as it relates to if you're running a sale process and you want to bring perhaps an iBanker in, making sure that you're selecting somebody that has experience in selling distressed businesses, that has a fee structure that is manageable for the particular situation. So I think just making sure that you're pulling in the appropriate professionals with the requisite experience, and that you've communicated appropriately upstream and if necessary to the court. Attorneys often will have to file, motions in connection with representing the receiver. So just documenting everything appropriately and getting things blessed that way is how I tend to proceed.
Perfect. Marty, can you talk to me about a receiver maintaining neutrality and effectiveness amid contentious litigation among multiple interested parties? I'm talking about the receiver's role as an officer, of the court.
I think the biggest thing to always remember is that you're the court's receiver, and your fiduciary duty, while you might have fiduciary duties to others, it does run directly to the court. Now, obviously it gets tricky because a lot of times receivers are appointed by a secured party. One party has, recommended you and brought you to the court, and, they're the ones saying this person can do the job and we need them to do this job. But at the end of the day, you're not their receiver. You're the judge's receivers. And I think we've all probably been in front of judges who have reminded us that you don't work for the plaintiff, you don't work for the secured party, you work for me. And so it's keeping that in mind. Now, a lot of times that your goals will align with one of the parties, maintain the collateral, sell the collateral, and maximize the collateral. But at the end of the day, you are that court's receivers, and it goes back to something we talked about earlier, which is, almost over informing the parties of what's going on. And that way, if someone has an objection to you taking a step, they can let you know. You can try to resolve it, or they can go to the court and say, hey, the receiver shouldn't be doing this. It usually doesn't happen, because usually you can talk through why you think this is in the best interest of the company or the collateral. But it's hard for someone to come back 6 months later and say, the receiver had no right to do this, when you have a stream of not only your order authorizing you to do it, but also all the emails and calls and so forth where you said, this is what I'm going to do, and then I did it. They had their chance to object. They had their chance to work out on it, and it's just sour grapes afterwards. So it goes back to what we were talking about earlier about, really providing information, maybe sometimes oversharing, and really just also at the end of the day, remembering that you are the court's receiver and you need to follow that order where, we've talked about that many times, but follow that order and work in the best interest of what the court wants you to do.
But, we talked about maximizing value, and that's pretty much the name of the game here, maximizing recovery. Rebecca, what methods or frameworks do receivers typically use to assess options for maximizing asset values or recoveries? What are some of the things that you look at or do, or what goes into that process?
Sure. Before I get there, I want to just add a couple things to
Sure,
what we've been talking about. Sander mentioned not going in without a budget, particularly if it's operating, and I couldn't agree more. Not just a budget, but a way to fund that budget. And I couldn't agree more. In fact, increasingly I have been adding provisions to my order that make it effective, but my responsibilities don't start until I file a notice, an affidavit, I don't know, one of those things, with the court that says I'm accepting the appointment. I know that's a little quirky, but it gives me a little bit of a buffer in there if I can't get it funded, because I'm not going to take responsibility for payroll, especially and federal tax obligations, if I have no way to pay it. I also wanted to mention, when I think about what I do most days, I started calling it, I'm a project manager with a fiduciary duty, because you really do spend an incredible amount of time managing professionals, and making sure that people are doing moving in the direction that you need them to be moving. And that includes the management, of course, at the companies if it's operating, but also just the professionals that you hire, and I love hiring lawyers. It's great. And I focus not just on the size of the case, although obviously that's relevant, given fee structures at various law firms, but also really the personality of the lawyer and what they're good at. If I know it's going to be litigation driven, which sometimes, unfortunately, they are, I'm going to hire more of a litigator, right? If I know there's going to be international features, I'm going to hire a firm that can handle that. So, it can be kind of especially in smaller markets, it can be a bit of a complicated analysis, I think, to get the right team together that you're managing.
Sure.
What was I talking?
Maximizing assets, recovery.
Maximizing assets. Well, we talked about maximizing the value operating or not operating, right? Mm-hmm. And that, that's the first decision. Obviously you're going to look at claims and litigation. I'm going to look at those, again, focused on net value. And that's going to include not just what I think, and I'm advised, could be recovered in various kinds of litigation, but how long that's going to take, because keeping the receivership open is expensive. And in order for you to sue somebody, you have to be appointed. And then how much it's going to cost. Oftentimes I will try to find an attorney, sometimes it's varying degrees of success, that will do it on a contingency. And then if there's enough, to keep the rest of the professionals paid while they're doing their thing, that can work. I've certainly done that. It's important, though, that all the parties understand, and I'm using parties broadly, not parties in the caption, that you're a professional client. So your fees need to be paid for talking to the lawyer who might be working on a contingency. Yeah. I honestly haven't found Well, that's not true. I have done a refinance inside of a receivership, and that works. And that was with real estate, and there was a nice equity cushion, so it worked. I got it approved by the court, and that actually allowed for the liquidity to pay professionals and keep it upright. But otherwise for funding, aside from the secured creditor, you might look at insiders depending on the situation. It's not unusual for them to come in with some post-petition financing. Sometimes potential buyers will do it to keep it upright so they can buy it. Occasionally, you'll get either a vendor or a customer that's really dependent on the business and receivership that'll come in because they want to keep it upright. And those are really the places I think I've ever looked to for funding to keep it moving.
Sure. Marty, what considerations should receivers take into account when determining the optimal timing for asset disposition, or how do you evaluate and pursue claims or litigation recoveries as part of maximizing estate value?
Sure. I mean, it goes back to the budget and how much money and time you have. One of the things I like to do, I practice a lot in Illinois, they like their receiver reports and the courts being advised of what's happening. I actually like to set an early date. Later we might go to quarterly reports or semi-annual reports, but I like to go in usually 6 weeks after the appointment, so I can give a quick, judge, this is what we got going on, and this is where we should think. Now, sometimes you don't have all the answers, 4, 5, 6 weeks in, but you have a really good idea of, am I going to get funded? What are, is this company making money as a going concern or losing going concern? And at that point, do I need to liquidate? Who I want to use to liquidate? Here's my liquidation plan. So you can get a really early on, because, in my experience, if the money, if the company's losing money when you take it over, trying to turn it around is not a great idea. You have your professional fees as a receiver, you're going to have your attorneys, you're going to have your accountants, and there's a reason that the company is losing money to begin with. And at that point, it's time to just turn it. Let's liquidate and close this. Because I think Rebecca mentioned, and it's a good point, the longer the receivership goes on, the more the expenses are going to grow. The budget concerns aren't going to happen. And, I know I've worked with some of the people on this call who are great receivers who can really manage a situation. But you hear the word receivership, you hear court hearing. It doesn't send a positive message to customers. And it's really hard in a receivership to increase business. So, if it's going down, I think you got to look at, unless there is an obvious answer that can be easily fixed, you need to look to, be liquidating the company very early on and getting in front of the court and explaining that's what you want to be doing. The pursuing claims, with one caveat, usually that is something that happens a little farther down on. The caveat is, you need to look right away to see if there's any statute of limitations. Get your attorneys involved. If you're worried about breaches of fiduciary duty, you're worried about fraudulent transfers. Most times you'll have some time. Usually, you could have years to deal with this. But if you have a hint of that, you got to identify almost immediately, when did it happen, and do I need to get something on file almost immediately? Usually that's not the case, and usually you can liquidate the assets beforehand, and then you hopefully have a pool of money that can be discussed with the parties to pursue claims, or maybe it's all just going to a secured creditor. But at that point, you can identify, what the potential claims are, how they will be funded, are there funds to do that? And usually, in my experience, there's a sequence of that where you're getting in. If you're liquidating the company, you're liquidating it first, and then you're pursuing causes of action. But I would really, really point out that caveat I pointed out earlier, that you got to be on top of the statute of limitations of these things early on.
Absolutely. And I know I want to get through a couple more questions here because we're getting to our hour. And if we go a little bit of overtime, that's okay. I'm just going to switch topics real quick. Chandra, what are first steps in securing, preserving estate property? What is typically stored, or how do you handle, the entire process of becoming a receiver, appointing as receiver, and having to make sure that you've got all these records, assets, collateral? Like what are the steps, and what are some of the keys that you look for and do?
Sure. So just a few things that might sound obvious, but things are again moving pretty quickly. So, try to get a fixed asset report from the company or an appraisal, or identify what tangible collateral exists from the standpoint of vehicles, I mean, anything that can move, right? You want to sort of get your hands around as soon as possible. Number one, vehicles can be dangerous. And number two, you have no idea where they are if they're not at the facility. So get a handle on those, park them, do what you need to do to make sure you understand if they're needed for the business. Obviously, you know, if you're operating, but understand what you have. Same thing goes for, you know, the equipment and whatnot. Is there potentially equipment stored at a third party for some reason? We've had that before where, you know, you find out a little bit later than you would like to that there's a piece of equipment at, you know, a friendly competitor's facility that technically is the collateral of the bank or whatnot. So identification of these assets, safeguarding them. If you need to, you know, store assets in a third-party storage facility, include that in the budget, explain to the lender why you think that's necessary. Maybe it's a capacity issue at the existing facility, you know, whatnot. And then, you know, the same thing goes for, you know, if you want to call it the receivables or the non-tangible assets or collateral, just having a good understanding of where that's at. What are you doing to make sure that cash collections are flowing appropriately into the correct accounts? Where are checks being sent that, you know, customers might be mailing? Making sure you've got some good checks and balances in place to, you know, cover yourself from the standpoint of ensuring you've got your arms around the entire portfolio of assets.
Okay. And then real quick, Rebecca, if there's insufficient funds to pay for, let's say you have a storage site or you've got a storage facility, like if there's insufficient funds, but it's absolutely critical to the receivership estate, you know, is that goes back to your budget, that goes back to running back to court? How do you handle making sure there's, you know, funds in a situation where there aren't funds to make sure everything's preserved and secured?
Hopefully I've thought about that before I've dispersed all the money. And I still have some cash. And, you know, typically I get a destruction order as part of my final account, like my disbursement order. I get to destroy all records. If I do sell it operating, I almost always try to transition them to the buyer, you know, with a transition services agreement that they have to maintain them until I'm discharged. These are more ways to avoid getting in that situation, Matt, than actually what happens if you get to that situation. I think there are certain instances, though, where you can't destroy them and you have to keep them, you know, if you end up having to do a healthcare case, for example. In those instances, you know, I think you have to go back to court and you have to get an order that requires somebody to pay for that. Yeah,
No,
I mean, my order certainly
that's
says
it.
I don't have to pay for that, but I'm not going to say I've never ended up doing that, you know, after all the money's gone and it's over and I'm still dealing with
Absolutely.
computers, records, emails,
Yeah.
whatever.
Absolutely. Marty, how should a receiver handle and evaluate destruction of, you know, the property if it needs to be destroyed, whether it's records or, you know, wiping computers? Like, what's the proper protocol steps that you see in from a timing standpoint too?
Right. It's really, you know, at this point of that, getting an order from the court. You want this for your own comfort. Also to give notice to the parties, because you might be dealing with someone else's information, or, you know, you don't know whose information it is. It could be employee information that they want their information back. And to give you cover to explain exactly how it is. Obviously, the healthcare caveat Rebecca pointed out is a very, very good one, where you have laws that you have to keep it for years and so forth. But you really want clear guidance from the court. And, you know, usually this is at the end of the case. I would, you know, tell everyone that you always want to reserve something for the end of the case scenarios, because this is one of them. But you're going to end up with computers. You're going to end up with some, you know, some PII, and you want clear notice to the parties, including, you know, employees and so forth, on what you're going to do, but also clear guidance to you and cover for you as the receiver on how you can go about destroying and wrapping up the case.
Absolutely. All right. Well, this is our last topic before we part here. Going into the reporting of the court. Chandra, what elements of receivership reports are critical for maintaining credibility with the court and stakeholders? You've been a receiver in various types of companies, situations of all shapes and sizes in various jurisdictions and courtrooms and judges. Everyone is unique in what they're asking for or not asking for, but it's just from a general standpoint, like, what is it that we are reporting? What is it that we need to report? What is critical to make sure that we're getting in those reports for all the parties and, of course, the court?
Sure, and just going back to the very beginning, echo what Marty said. I think it's critical to be present in court when you're appointed, because you will need that judge at some point during the case, and I'd rather start off on the right foot than stumble out of the gate. So, and that could even mean, you know, the acceptance of your report. So I tend to be as complete without, you know, delivering a 50-page report if it's not necessary. I tend to focus on, you know, what was achieved during the period that you're reporting on, what issues maybe arose during that period so that the court has a good understanding of that. How did you handle those or deal with them? So just sort of summarizing the period for the court. We always include a weekly cash flow of the activity that took place. Typically that will be required in the order. Everybody wants to know how, from a liquidity perspective, the company is doing. Probably a P&L and a balance sheet if you're operating as well, if you can get to that sort of level of detail, depending upon the resources that you have at the company. So you know, that's just generally what is included. If there's any major activities that took place, if there's a, you know, if it's a reporting period and there's been a transaction or something significant happened, obviously you would expand on that in the report, but otherwise it's a little more general just to keep the court informed and to comply with obviously the order and the reporting requirements contained within that order.
Excellent. Rebecca, you mentioned earlier about reporting to the court, doing it maybe a little more frequently or monthly, or what do you think is the general timing? Should it be monthly? Should it be quarterly? Does it depend on the situation? What are your final thoughts on that?
I mean, I think it varies on at what stage you're at in the receivership. You know, I'm going to start moving it more, especially even later on in the case when it, you know, you could be 18 months into it where you haven't actually heard from a customer, an employee, or a creditor, you know, in a year. I don't think it's a bad idea to have that record though, and I'm leaning toward more reporting rather than less. You know, this is like how my order keeps growing. You know, these are things like I've been doing this for 2007, I think, was the first time I was appointed, but it keeps evolving. My practice keeps evolving, which I guess is a good thing. So
Sure.
I think more reporting is good. I would also just throw in, you know, to bring us full circle, you need to look at the order and see what it requires. I have one right now that requires the normal, like Sandra was talking about reporting, but then also requires that I file what the order defines as a master service list, which has nothing to do with the matrix. It's just the specific list of creditors that I update monthly.
Sure. Marty, go ahead, sorry.
No. So I think it's important to look back to the order because I wouldn't think about that.
Yeah, Marty, any final thoughts?
Yeah,
Reports?
I would just say don't hide the ball and hide the bad. You know, you were appointed for a volatile situation. If there's a hole in the roof, there's a hole in the roof. You know, you'd rather get in front of the court and let the court know all the problems early on and in every report than anyone come back at you later and say, you know, why didn't we know this? We would have done something different. You know, you were brought into a very problematic situation that has, you know, already evolved to a court hearing. Let the court know exactly what's going on. Obviously, there's a desire to show, hey, I'm doing such a good job, but you know, at the end of the day, you're the court's fiduciary, and you want to be entirely transparent on all the problems that are out there.
I agree. Well, I just want to thank you guys for such a great panel. Thank you, Chandra. Thank you, Rebecca. Thank you, Marty. This was absolutely fantastic. And, you know, we probably could talk the rest of the afternoon, to be honest with you guys, going into the evening about all of our stories and everything we've done. And really, this has been such a, like I said, it's a Titans of Industry type panel. Real quick, I just want to thank Daily DAC and Financial Poise. I also would like to thank the National Law Review as one of our co-producers, as well as our sponsor, Max Asset. Thank you, everybody, for joining us. We have another series next week, episode 3 on asset sales. I'd love for you to join us. Thank you so much, Matthew Brash here. And again, on behalf of our panel and Financial Poise and Daily DAC, thank you so much for joining us. Everyone have a great day, and we look forward to hearing from you and talking to you soon. Thank you, everyone.
Thank you.
Thanks.
Thank you.